The corporation's power of section 5120 is one of the most controversial heads of power in the Constitution. But it wasn't always like that. For a long time, the jurisprudence of the High Court of Australia was stable in terms of the meaning and extent of section 5120 of the Commonwealth Constitution. And this happened because of a case called Huddart and Moorehead from 1909. The interpretation of section 5120 only started to change afterwards, especially after another case called Strickland and Rocla concrete pipes from 1971. In my next video we will talk about the concrete pipes case, but today we will focus on the case that led to the stabilization of the High Court's jurisprudence for over 60 years. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we'll analyze a case called Huddart and Moorehead from 1909. If you have been watching our videos, you will remember that in 1909 we still had Samuel Griffith's court. That is, the justices that sat in the High Court were Chief Justice Griffith, and with him Justice Barton and O'Connor and Justice Isaacs and Higgins. The first three justices would constantly defend a more federal view of the Commonwealth, with priority given to the principles of the state's reserved powers and the implied intergovernmental immunities of instrumentalities. We have videos about all of this in the playlist that is appearing above. So in 1909, the constitutional cases were based on these presuppositions of the court's composition and the principles that they emphasized. For the majority, the state should maintain their continuing powers after the federal constitution. And so one effect was that the Commonwealth was not to enlarge its powers by a broad or literal interpretation of the heads of power, or through a narrow characterization of laws. So with that in mind, let's take a look at this super relevant case. Let's start with the facts. The Commonwealth regulated trading activities through the Australian Industries Preservation Act of 1906. In sections 4 to 8, the federal law penalised companies that engaged in combination or monopoly to restrain trade. When a Victorian shipping company called Huddart that traded in coal was asked to answer some questions about their trading by the Customs Office, Moorehead, and refused to answer them, the company was brought before the judiciary. Moorehead laid an information against Huddart and the company was convicted by a Victorian Court of Petty Sessions for breaching sections 5 and 8 of the Act. But the company then appealed to the High Court of Australia. Huddart argued that section 5 and 8 were invalid because they were not aimed at regulating corporations under section 5120, but intrastate trade and commerce. Their argument was that the Commonwealth Act was in effect designed to control trade activities, whether intrastate or interstate, engaged in by corporations. All in all, since the law pertained to intrastate trade rather than to the constitutional corporations of section 5120, it was outside the legislative powers of the Commonwealth. The question before the High Court of Australia then was whether the specific sections of the Commonwealth Act were valid laws under the corporation's power of section 5120. In answering this question, the High Court was invited for the first time to inform the scope of the corporation's power. How did the High Court decide? The majority of the court held that the provisions were invalid. The majority was composed of Chief Justice Griffith, with whom Justice Barton substantively agreed, and with two other separate opinions from Justice O'Connor and Justice Higgins. Justice Isaacs dissented in the case. But the majority basically upheld Huddart argument, and they upheld it based on the notion of the reserved powers of the states. Why? Because the effects of the law were impinging on an area that was reserved for the states. Intrastate trade and commerce is not a legislative power of the Commonwealth. The Commonwealth cannot legislate about that.
But, Renato, the law was about corporations, and the Commonwealth can legislate about corporations.
Yes, that's true. But remember, the High Court, back then, adopted a substantive characterization of laws, meaning that they would analyze the federal law as a whole, considering, among other things, its intent and effects. Here, the provisions were not necessarily regulating constitutional corporations, inasmuch as it also aimed at restricting the state's internal trades. For the majority, the federal structure of the Constitution, expressed, for example, in section 51.1, reserves the internal trade and commerce to the states, and the Commonwealth could not legislate about that. In fact, Justice Higgins warned of the problems of allowing an unrestricted enlargement of Commonwealth powers. His Honour said that if the federal parliament could legislate anything about corporations, the result would certainly be extraordinary big confusion. He did not know, however, that his own position in the ingenious case would be used to ultimately expand the powers of the Commonwealth in many respects, including the power of section 5120. We have talked about this already in another video called the Work Choices case from 2006. You can watch by clicking on the top right corner. But as I said before, Justice Isaacs was the only dissenting judge. For him, the corporation's power should be interpreted more widely. It should encompass the powers to regulate the conduct of the corporations in their transactions with or as affecting the public. And remember, he favored not only a literal approach to interpreting the heads of power, but also a narrow characterization of federal laws, which meant that he rejected the idea of the state's reserved powers that based the majority's decision. In the end, this case became the authority on the meaning of the corporation's power until 1971, when the High Court was invited once again to re-examine section 5120 of the Constitution. We will talk about this case from 1971 in my next video. But there's still one more important point that I would like to make here. The case of Huddart Barker has another layer, and this layer relates to the possibility of a public officer exercising certain powers that seemed judicial in nature. In Huddart Barker, we have an important decision of the High Court concerning the nature of the federal judicial power as per section 71 of the Constitution. This aspect of the decision, for example, was unanimously decided. All justices agreed about the meaning of the federal judicial power and whether it was being exercised in that particular case. Because of the significance of this aspect of the decision, I will make another video exclusively about federal judicial power and the decision in this respect here in Huddart Barker and Moorehead. If you do not want to miss that video, and if you want to know what happened in 1971 with the decision in the concrete pipes case, I would kindly ask you to subscribe to our channel and click the bell icon as well. This is the best way to guarantee that you won't miss my next video that's coming up. I hope to see you then. Ciao.